Next is Dr. Amnart Tangkiriphimarn, Associate Dean for International Affairs and International. First is Dr. Vanina Sucharitkul, Program of Faculty of Law, and Director of the International L.L.B Program at Thammasat University, International Arbitrator, Senior Lecturer at University of Paris, Descartes, Co-President at Yong THAC, Chairwoman of CIArb Thailand branch. And fourth is Professor Darius, faculty member of Singaporean University, Pung School of Law, Deputy Director of the Singaporean International Dispute Resolution Academy, Director of the SMU Law Academy. The session will be moderated by Mr. Natthawat Sirprasomsap, Legal Counsel at THAC. Not to do any further delay, I will give the floor to all our distinguished panelists. Thank you.
Thank you. Good evening, everyone. Welcome to the second discussion of today's event. The topic of this session is the role of education in ADR. My name is Natthawat, Sirprasomsap, legal counsel here at THAC. I will be the moderator of this session. We are truly honored to have such a diverse panelists today who have been educating various jurisdictions. Before we begin, I would like each panelist to introduce yourself and tell us about your background, on your legal education, to be qualified as a lawyer in the system, and what are you currently working on as a lawyer?
Maybe start first. Okay. Good afternoon, everyone. Dr. Tidarat, background, former Vice Dean for International Affairs, and now I complete my term, so you still have to. Yeah, I'm teaching a variety of subjects at Chulalongkorn University, international business laws mainly, and also international arbitration, both commercial and investment arbitration. And also other courses as well, mining laws, petroleum law, and sometimes also something on natural resources, construction law. So a variety of topics that I have to teach that. And now I'm also on the list of arbitrators list of the TAI and TSAC, and also serving as the TSAC Arbitrator Committee as well. And also some other experience that I think one thing I want to take up a lot of time. So that is a brief introduction. Thank you.
Professor, can I ask about your current project? Are you currently working on something like that?
Actually, I think very soon we will launch the Center for Dispute Resolution at Chulalongkorn to combine anything about ADR to provide some platform to show the student work as well, the research findings, and also to provide some of the capacity building activities for the legal community in Thailand, also have some of the foreign institutions to join us as well. So that one might be the main project we want soon. And in terms of their academic work, especially a lot of my work focusing on treaty-based arbitration, but at the same time, we also do something about many types of out-of-court dispute resolution, including like class action settlement, those kind of things. So that's it, basically the main work.
Thank you. Amnart, please.
Good evening, everyone. My name is Amnart. So I'm the Associate Dean for International Affairs, bringing the word that she did before. And I'm also the Director of the L.L.B program, International one right now. So I did my LLM, so I did complete L.L.B at Thammasat University, and then did LLM and JST at Yale Law School. So my doctoral dissertation is on indirect expropriation. So right now I teach inter-area like international arbitration and also international investment law. So you can see that our fields are quite overlap. So we see each other at many events like this. Apart from, let's talk about my current project right now. So I think so there will be an article published in a book in memoriam of like Professor Jose Alvarez, who passed away a few years ago, and I wrote an article with my senior colleague, Natthawat. We studied with him at Yale Law School, so we wrote an article, so it will be published they said on the 2nd of January. So it's about abuse of right in international investment law, corporate restructuring. So if you're interested. And apart from that, working on YTHAC with Vanina, so we try to promote the use of ADR and arbitration in Thailand to younger generations. I see that there are some students here with us today. So that's about myself. Thank you.
Thank you, and thank you, Natthawat, and thank you to the THAC, and I'm very pleased to be amongst my esteemed colleagues today, and I hope you all had coffee today, because it's going to be a very exciting session on education. Just a little bit of background, because I think you mentioned we all come from very diverse legal systems. So the foundation and the way that we study is very, very different. Before I moved to the US, I went to a Thai school, Thai school. And then I moved to the States, and the legal system in the US is that you have to do a bachelor degree first. So I did my bachelor in English literature at UC Berkeley. And then you take an exam and then go to law school, which is a professional degree called a Juris Doctor. It's not a research degree. And then you qualify to take the bar exam for 3 days and qualify as an attorney. So I'm not an academic by nature. I've been a practitioner. I always wanted to do arbitration. My friends tell me I've been dreaming about arbitration since before law school. So I started practicing at Morrison Forrester in San Francisco, and then joined Herbert Smith to do arbitration for the time, and practiced in Thailand, Paris, and Hong Kong. And then did my doctorate in France on investor-state dispute resolution. And now I'm back in Thailand and will be returning to private practice at the beginning of next year. Can't tell you where yet. But as far as projects, I think with the Chartered Institute of Arbitrators, one of our big aims is really to train and accredit arbitrators in Thailand. Because as an international organization, that goes through a rigorous process, such as award writing exams that are graded by line graded with the same standard. I think this is one of the resources or one of the complaints when I was practicing in Thailand, that the pool of arbitrators is not large enough. So that is one of the projects, I would say.
Thank you, Dr. Vanina. Please, Professor.
Good evening, everyone. My name is Darius. I was last in this office about 3 years ago, so it's very good to be back and to learn from everyone. Just to set some context for my comments later, I did my undergrad law degree in Singapore, and at the time when I did my law degree, Singapore only had one law school. Right now there are 3 law schools, but at the time, many years ago, there was only one law school. Law school in Singapore is 4 years long. Right, so I did 4 years of law school, and after law school, you have to do very much like the English style. You have to do the bar exams, and then you have to do a training contract with a firm before you can get called to the Singapore bar. So we did all that. Fast forward now, I'm now full-time faculty at the Singapore Management University. I practice full-time as well as counsel and as arbitrator in both commercial and investment arbitrations. And as far as my projects are concerned, I'm the Deputy Director of the Singapore International Dispute Resolution Academy. Very happy to share about the ideas and initiatives and events that we're doing over the course of the next hour or so.
Thank you, Professor Chan. So I would like to jump on our discussion today. I have a question here to ask specific to Professor Chan and Dr. Vanina. So I would like to ask, what do you think that the universities or law school could have done better to prepare you from the past experience, to prepare you or other students for a legal career? Professor Chan.
So when I did arbitration in law school many years ago, there were very little arbitration courses on offer. It was just plain vanilla commercial arbitration. That's it, right? There's no variety at all. Fast forward more than 20 years, at the National University of Singapore, for example, I last counted in one term, they're offering at least 10 courses on arbitration, sports arbitration, IP arbitration, investment arbitration, investor-state mediation, etc., etc. So that's how far advanced 20 years have seen, or more than 20 years have seen. At my university, we are always thinking about how we can improve the curriculum. And we've talked to the industry on this. And interestingly, and this is what I hope to provoke a discussion, there are two schools of thought. The first school of thought says that law schools should focus on practical training. We must teach students about the practice of law. And that means telling them what to do when they meet clients, telling them what to do when they're in court, telling them what to do to handle their partners, to handle fellow associates, etc. So that's one school of thought. And I thought that would be a popular school of thought. Surprisingly, when we talk to the industry, there's a very strong second school of thought, which says that law schools should keep to teaching the law, make the students well-versed in black letter law, let the practical training be done by practitioners where the expertise lies. So interestingly, there are two competing schools of thought. For my own personal view, I think there's a balance to be struck, and there's a realization of reality that every university will have its resource constraints. So to the extent that an individual faculty member can infuse practical skills into his or her course, that's fantastic. But my sense is that most of the practical training is likely to come from sources external to the university. That's just my own personal view, and I'm happy to discuss that with the panelists and the audience today.
Thank you so much. I have so many questions in my head right now. I'd like to ask you. Dr. Vanina, please.
Hi. I think well, first I would say one thing that I thought my law school did really right, which was it had a career center and a mentorship program. Because when you're young and you go to law school, a lot of people don't know what kind of lawyer they want to be. They say they want to do criminal law, they say they want to do any kind of law, but at the same time, they don't know what a day-to-day like. And what my law school did was actually kind of schedule for students to meet with alumni to do what we call informational interview, where students were interviewing lawyers to find out what is a 9-to-5 day like for you. What do you do? What are the tasks that you do? What do you like about what you do? So that you can find your career path. And I thought that was something that was really good about my law school. And our career center also had a CV clinic, and that helped students to be as successful as possible, including mock interviews. I think what can be done more, because it was in California and the US is very into domestic law, and it's not very much into international law, is that there wasn't so much resources. California is known as being very anti-juristic arbitration. In fact, as a place for arbitration, if you think of Thailand and the work permit, was unless you had a California bar, you couldn't even conduct an arbitration that wasn't under California law for a while. So this is kind of why I left California. But the international exposure, and I think that part was really missing. And I think this is where we kind of start to have dialogues, and here we see people from different jurisdictions and different legal systems. And one thing about the teaching methodology is that, I can see from civil law to common law countries, is that in civil law, at least when I was going to school in Thailand, you were penalized if you asked a question. My teacher would tell me that if you asked a question, it meant you didn't listen. And so people were not encouraged to kind of, at least, I felt not encouraged and a little bit more shy than my American peers to kind of volunteer myself, to put myself forward, etc. But with the US, the JD learning system is you learn by the Socratic method. So you learn by the teachers questioning the student. So that is very different from the teacher lecturing students.
Any question for us?
A different question prepared for you, but it's further from the last question, which is, given that both Professor Chan and Dr. Vanina have stated some problem from the education that were missing when we were in school, Now, from the side of the active professor right now, do you have any innovation support or training that you think should have been added to your course of teaching or to make a student to be a better lawyer?
Sure. So I first want to address the point that Professor Chan raised, how to balance between practice and theory. And I think it's become more and more blurred today, at least in the courses that I taught. For example, I invited many practitioners to come to my class to share their experiences with the students. And I think when we talk about ADR, so when I talk about ADR here, let me focus on arbitration in particular because that's my area of expertise. Arbitration is quite a kind of unique subject that professors who teach this subject is normally practicing in arbitration as well. For example, I do sit as arbitrators and Tidarat sit as arbitrators as well, so that we can gain experiences that we learn firsthand from conducting cases and share with the students, of course, with some reduction, right? Because arbitration is confidential, so that's one thing. So there's, I think there's advancement in that respect. So we involve more and more practical sides and try to kind of like blend it with the theories part. And then when we talk about how to prepare students into, let's say, ADR arbitration careers, I would say you have to talk first, what careers are you talking about? And I put it into maybe 4 types. Advocacy. For this, I think that's what professors in Thailand lacking. We don't have the privilege that Professor Chan have, where he also practiced as a lawyer's counsel and at the same time teach in the university. I don't think there are many professors, law professors, who do that, right? As for another career that can be done is, of course, arbitrator, and maybe the court or the judge who decide like or review arbitration awards. I think universities in Thailand are doing quite well on that. We teach them what the law is substantively. We teach them how the arbitration law is about, so that they can conduct arbitration process, right? So I think we do that quite well as of now. But lastly, I think another area that we can improve is about the administration of the arbitration process itself, which is a career that has not been focused much in Thailand until today. For example, we have legal counsels as Natthawat and Vanina who sit there doing all the case administration for THAC cases. I would say it's something that you cannot learn from the classroom. I mean, I had the privilege of doing that when I worked at the PCA in 2017, 2018, so I know like how the admin stuff is done, right? But if you don't, if you're not in that position as legal counsels, it's impossible for you to know what's your work. Do you draft the PO? How much involvement you do with the arbitrators' deliberation, for example, right? So these are things that I think we can focus more on, prepare students to become maybe legal counsels in these institutions. And I would say it's one of the best ways to learn how arbitration works apart from being counsel. And I give it that.
Thank you.
Okay, same question. Actually, at Chulalongkorn, if I talk about the L.L.B program, the bachelor degree, we have both the ADR course, and later on we also have the course focusing specifically on international arbitration as well. I think for me, my first impression when I was assigned to teach ADR, I feel like even in the ADR course, but the lecture mostly focused just on the arbitration. I think that is the main problem. So when I got assigned to teach, I tried to make sure that I provide the right balance to other type of ADR as well. Because, for example, if you look at the Queen Mary survey, you can see that one of the, I think the most favorite method of dispute, cross-border dispute settlement is arbitration combined with ADR at 59%. And by that survey, ADR include other type of dispute resolution as well, including like, not just mediation, even also for the dispute for the other type of the construction, arbitration, construction dispute, and also expert determination, negotiation as well, of course. So I try to make sure that in the ADR class, we have a fair balance for other type of ADR. And to add that gap, I I have invited some of the practicing lawyers, and this year we're very lucky that I already invited Sinlapapiromsuk as well to get the award, right, for mediation. So I think the contribution from colleagues, from practicing lawyers, law firms, and many type of external institution would be very meaningful here to add in that gap, and including for arbitration as well. And also, I think for arbitration, I personally try to update myself as well, try to teach students with the real world example. For example, when I teach, I take example of the treaty-based arbitration. I like to discuss like the issue, like the current issue as well, like the SPV as well, special purpose vehicle, it has some implication on the issue of jurisdictional defense. Because in Thailand, I feel like when I come back from the US, I feel like many people talk about the state of enforcement of arbitral laws, which seems to be a main problem here, at least on the perception of many practicing lawyers also. I feel like there is a kind of a gap in literature discussing on the issue of jurisdictional defense. I feel like even for the government sector, they need to be educated as well. And those future people in those sectors are our current students. So I feel like we have to increase the knowledge on some type of government counterclaims in arbitration at the jurisdictional phase as well. But at the same time, I try to make sure that I'm not biased. I try to show them also certain cases where those type of government counterclaim at jurisdictional defense things might not be kind of legitimate as well. So there are a lot of new issues, hot topics that I try to include in my course. So I think with the collaboration with external institutions, practicing lawyers, and also with the professor trying to update using the real case, even the current, big news on the Spanish law as well, the big cases. I think they got to most often this day in the last 10 years, the Spanish government regarding the renewable energy sector law. So those type of new trends, if we include in this type of course, I think students would get the practical knowledge at the same time with the theories.
Thank you.
Can I share one example of how we have tried to bridge the gap between theory and practice? And I'm just throwing up there for consideration. We thought about how students are telling us, what we do after graduation, we want to become accredited, we want to gain accreditation, professional accreditation. Does that mean we've got to pay for an expensive course, and then will my law firm let me attend the course, and so on and so forth, right? So what we thought we would do at my university, and we're trying this out with mediation, we designed a mediation course. And in Singapore, in order to become an accredited mediator, you need to do 40 hours of training, right? So level 1 mediator requires 40 hours of training. So we thought, all right, first 20 hours, we'll structure it as a university course. So as long as you take this university course, you satisfy the first 20 hours. The other 20 hours, I'm afraid you've got to do a professional course with other people, with other external participants, etc. So in a way, it's not a complete solution, but we at least try to make it slightly easier for students.
Thank you. I have a question. I'm sorry, this question is unprepared. I just think of it. I would like to present a view from a student point of view, because I recently graduated, and when I chose to do my LLM, I chose the program is called International Dispute Resolution and Arbitration, which from my point of view at that time, no Thai student choose this program. I chose it out from out of nowhere, out of interest, because I chose it because it's in the Netherlands. No Thai student goes there. I think it's because I want to try something new. But I wasn't sure at that time, and I believe the student will think of this as the same, because ADR compared to normal litigation, will I have a job if I go to choose this path? So I believe it's how can we encourage students to go down to the ADR path? Dr. Vanina?
How do we encourage students, or what do you mean?
Well, I think every student has some point when they were in the bachelor degrees, they don't know what to do with life.
Yes, exactly.
So how can we encourage those students to say slightly not them to choose to go down with the ADR part?
Well, I mean, it has to be a passion too, right?
Yeah.
Because you can't be good at what you do unless you're passionate about it. But I think educating on arbitration and mediation as an option is very important. I think this is part of what the Academy is doing. And this is part of why there are webinars. And most importantly, what I noticed is that when we did the launch of the YTHAC webinar, there were attendees from Africa, from Switzerland, all kinds of countries about how to get a career in arbitration. And but I think what is important, this most selling point for arbitration is when it comes to international transactions, right? So I think that's the part that needs to be stressed. But in terms of students, at least I would say when we were talking earlier, I want to get back to the practice and theory, at least with my arbitration course, is I tell them when I started law firm, I had no idea what I was supposed to do. And I think most of my peers, we didn't know how to be a lawyer. We start our data firm and we come in with our imposter syndrome. We come out, we think, oh great, we graduate, we pass the bar, but then, oh, we don't know what to do next. So what I try to do with my students is that, okay, I want you to at least know when your partner tells you to draft a reference schedule, what it is. When he asks where it falls in the orange list of the IBA guideline on conflict of interest, what that means. If he tells you to draft up a procedural order for him to review, what that is. So those were the exercises that we would do in class, in addition to parts of the books.
Thank you.
You can add something. I think one way to encourage students to like enter into this kind of program, ADR arbitration, is just to look at people in this group, right? Because all of them work in arbitration ADR. Thomas, Amy, Anthony, and Anita, Roland, right? And Natthawat, and Vanina as well. And I think if we kind of like invite these people to talk to students, that's the university's role to create maybe inspiration. And I would think that every big law firm in Thailand has like litigation and arbitration department, and some even just have arbitration department by itself. So I think things are getting much better now, and ADR and arbitration, because we teach them in the classrooms and they get exposed to this area of law. I want to address one point that Kunapama mentioned in the first panel, whether ADR arbitration should be a compulsory subject or not. I mean, in my view, I'm in the camp that you should have as least as possible compulsory subjects, so that students can choose what they want to do. And I may disagree with you whether we should put this into the compulsory course. So what we can do is to use kind of like soft power. This is one of the options for you. If you enter into this course, you will learn some many interesting cases, and you will have a great future career. I think that's a better way, in my opinion, at least. Yeah.
Okay, I may just add something. I don't want to block you, but God, we don't have that problem because ADR course is one of the most popular selective course, like more than 100 students enroll in that class. So that's just kind of my problem to mark their papers. But actually, I think one of the main kind of incentive, I agree with Ajahn as well, to invite the inspiring people in the area, in the industry, the lawyers as well. Actually, this semester, I have a friend, a lawyer from Singapore, to give an extra or special lecture for this ADR class on a very different topic, which is about like ADR and psychology of ADR. So he talked about even something scientific, what happened to the process of the brain, something to do with the bias, how can you recognize or notice or observe the manners of the arbitrator, of the mediator. I think actually Amy also specializes in this issue as well, psychology, of the ADR. So students somehow have a very excellent feedback on that. He never been taught about this because most of the time it might be more on the theory side. Because the lecturer also from Singapore, he also give like example of this type of conversation, the reaction, what type of thing that you can predict what's going to happen, the way in practice, what are the factors that you should think about when you appoint a mediator as well, or arbitrator. So a lot of things. And also for me, I secondly help my student at law school by teaching, because I got invited to teach at the business school as well, both at the BBA and also at the Master of Management. I think if the real end users in the industry, those entrepreneurs, those working at the big corporation, if they're aware of the use of ADR, which is something that truly and meaningfully affect the cost of business. If they know, they will of course use this type of method. If demand has been created, my student lawyer will get employed. Of course, it's like I teach them, I taught them many topics because the course is actually international business law course, but I intentionally put some ADR in there. Surprisingly, one of the topics that is the most popular with the student at the business school is the topic of ADR. And they said that they never know before what it is, arbitration, what it is mediation. But once they know that there are some real impact on their cost saving, and even to maintain some like long-term business relationships, so that it's not just litigation. So if you raise the awareness outside law school, the real user as well, I think students will have more demands, and there can be some like prosperity in their future career as well. So that's what I want to share.
Thank you. Sorry for going off track a little bit. So let's get back on track. So onto the specific matter. I have a question for Dr. Vanina and Professor Chan. As an international arbitration cases involving Thai parties are on the rise, what kind of trainings do you think that necessary to make a better counsel in arbitration cases? I think most of our practitioners here, they would love to know about this.
I think training on written advocacy is very important, and because there are many different, because we're dealing, when it comes to international arbitration, it's really a mixture of civil law and common law, right? And in domestic arbitration, if I'm doing arbitration with TAI, it has a very specific format. But if you start mentioning memorials versus pleading styles, then that's not something that is known necessarily if you're only practicing arbitration in Thailand, because the domestic arbitration almost kind of follows the court style. But to build a memorial, for example, versus a pleading style, or how to draft effectively pre-evidentiary state. I think these are very important. Writing workshops, there are different ways to structure arguments, how to build a case theory. So based off of scenarios, I think hands-on, as well as oral advocacy is very important.
So there are a variety of courses out there for arbitrators, right? For the CIArb course, we've got IBA designing various toolkits to help arbitrators write awards. And for mediators, we know there are accredited mediator training programs out there. In my view, there's a gap for training for counsel. And in one of the better training I've attended myself in Singapore, it was a 1 week long program, and this is something that the THAC Academy can consider. It's a 1 week long program which uses a case study approach. They invite practitioners, they invite government officials. For 1 week, you are all in one room working on one case study. And as the case study unfolds, you learn about the various topics of investor state arbitration, expropriation, SDS, protection and security, etc., etc. So 1 whole week long, you're working through the process, and it culminates into a written brief and a moot. So it was extremely tough, but extremely well received. Although the feedback that I heard from the government officials was they loved it because it was the first time they heard they had a one-stop shop place where they could learn about all these topics. But for the practitioners, the gripe that I heard was that it's too long. The law firms had to release them for 1 week. So that's all, again, that's always a balance to be struck. But that's one idea that the academy can consider.
Thank you. We have anything to add? Given that we already talked about trainings in arbitration. Now, I think ADR is not just arbitration, but also things like negotiation, conciliation, or mediation. So I have a further question for two of you. Where actors are either party representative or decision maker or the mediators, can you tell us about your thoughts, for example, what would make a good mediators versus what made a good arbitrators?
I'm happy to take this because my university is really pushing the mediation mandate, right? And in selecting a mediator, I don't want to offend anyone in the room, but we try to avoid ex-judges. Yeah, and you can probably see where I'm coming from, right? We try to avoid ex-judges who will immediately decide on the right and wrong. That's not really someone we would like in a mediator. We like the mediator to engage the emotions of both parties. And we found that the most effective mediator leaves aside the legal right and wrong, but really teases out what is really emotionally, the emotional stumbling block behind resolving the dispute. It's very difficult to train this skill because in law school, at least speaking for myself, I was just trained on the law, right? This is what it is, and you don't talk about emotions. You don't even write I believe in your answer. It's I submit, or I suggest, or I argue, right? You don't write I believe. So it's a complete different mindset. And for that purpose, we've started designing clauses for mediation advocacy. How do you conduct the case as a mediation advocate and as well as a mediator?
Yeah, that's quite interesting because the one successful mediation we had was a Singaporean ex-judge. Because it was actually, we were representing a foreign party, the other party was Thai, and we were going to CIArb arbitration. We halted it and went to arbitrate at the Singapore Mediation Center. And the former judge wrapped it up in 1 day, and our client was very happy, and I went to pick up the check from the hotel. So on the other hand, we had an arbitrator who mediated, and it was a total disaster. And interestingly, because Thai judges mediate as part of their role all the time, one of our clients was so surprised that the judge managed to get a result that same day, whereas our arbitration had been going through guerrilla tactics for about 2 years to appoint an arbitrator. And then in the other case, the law firm tried to deny that they ever received the arbitration clause to begin with, so there wasn't one. But in terms of an arbitrator, is an arbitrator who can control and manage a case. Beyond just being independent and neutral, is oftentimes what I have seen, at least, if I worked in Hong Kong or Paris, there wasn't necessarily a problem of best practices of parties kind of abiding by the rules of engagement. But when we're talking about Thailand as a safe seat, the issue of guerrilla tactics, which we actually did a seminar here back in 2017 on guerrilla tactics in international arbitration. And all of the war stories from when Neil Kaplan was arrested at the airport and called the Chairwoman who was there, and all the people who were in that case. And after that, Thailand got a bad reputation. And until today, we have arbitrators who, when Thailand is a seat, they will change the venue to Singapore, just have the hearing in Singapore. So an arbitrator who can control that lawyering, who are disruptive, who are trying to challenge, disrupt, delay, ask for ridiculous extensions of deadlines at the last minute. I mean, we're not talking about extreme cases like an arbitrator being kidnapped, like the case in Indonesia. We're talking about the 10-year arbitration cases that keep happening in Thailand. Why do cases take so long, right? So arbitrators who can control time and manage time, I think, is one that is good, who can give parties directives. And write enforceable awards. Most importantly.
Thank you.
So what we learned from listening to speakers here is that being arbitrator is one thing and being mediator is another thing. They use different set of skills, right? And even in mediation, sometimes you may want an ex-judge to be your mediator. So if you think that it's suitable to your case, so I think this is maybe a good thing about ADR because you can kind of like try to design or influence the process. Yeah, you can pick. Apart from being selected by the court chief of the court or something like that.
I think for me, although I have not long experience for mediation because at my time in law school we don't have this class at all. I don't know if it's the same for your generation as well. But yeah, but actually because of THAC, thanks to THAC, you have a lot of competition from this. So some of my students got a lot of inspiration from attending this kind of mediation competition hosted by the THAC, and then when they go back to law school, this year they even create a student initiative for the setting up the ADR part focusing on mediation as well because of THAC support. And we're gonna plan to do training for that. And for I think one of the student team, they came to meet me before they take part in the competition at THAC. They asked me, because I just finished my arbitration lecture and they just wait for me outside the room and they asked me like, Professor, give us one sentence advice. We're gonna participate in mediation competition at THAC. I said one thing: don't use the law. Don't use the law to judge it because it's supposed to be facilitator, and the outcome can be something like win-win or innovative outcomes. And you can use several techniques, But that is something that's different because this day, if you treat like ADR in or picture. You can, in the past, law lecturers usually say that arbitration is so flexible, litigation is so rigid, formal, etc. But this day, you can't just talk about the two. You have to put mediation on the scale as well. There are different spectrum there. For mediation, if you put it in this picture as well, I think arbitration rather be quite formal in the sense that you still got one party who wins, one party who lost, because you still have to have the governing law. Especially very, very first issue before arbitrator can decide who wins the law, you have to find out what the governing law are. Because if you're not accurate on that, your award could be challenged as well. But for mediation, you can try to find the area of compromising area, to make sure that they might, reach something that both sides can compromise on. And I think that is also something that distinguishes as well between the arbitrator and mediator duty. So maybe that's it that I want to add.
Thank you. One last question. This question I would like to ask Dr. Tidarat again.
You don't want me to take a rest?
I would ask, how can other entities or organizations such as government entities, law firms, universities, and also I can see from there's an engineering council can contribute to the education of the ADR?
Right, that's a very good question. I think I heard from the speaker in the first panel as well mention about we have to create the right ecosystem for the ADR. So we need to integrate many institutions, many stakeholders in the community to help, make the awareness the support as well to this community. Basically, I think there are many roles that other institutions can play. For example, as we all here already mentioned, we need the expertise from you as well to tap in terms of the practicing part of the ADR. And also, for me, if I talk also about another program that I'm teaching, which is L.L.B Master Degree Program, in fact, many issues that you mentioned in the first panel are already in the research papers of my student, like third-party funding, or one of my students did that as well, even a few years ago. So, and also even on the interim measure, we try to encourage the student to provide some more meaningful and more detail-oriented. And I think THAC also having the same report research project as well on interim measure, because I've seen the previous research that they just usually mention about whether or not Section 16 should be more clarified to give the express power to the arbitral tribunal. But I don't think it's enough. I'm not going to know that much because I compare to the overseas, the foreign jurisdictions. If you look at the UK Arbitration Act or even Singapore version, they go into even the detail, not just like one size fits all, but you have to mention each specific type of interim measure. You know, we have different type of things. The freezing order, you know, security for cause. So many types, you can't use the one size fits all. So I try to encourage them to look at more details in their thesis proposal. And also in this regard, you can see that something, it never ending the learning process. Even in Singapore, they have a lot of advanced rules already. But right now, if you follow the news, SIAC also in the process of revising their rules, at least in 5 areas, if I understand correctly, like expedited procedures, like emergency arbitration, early dismissal, and also publication of the award or other consolidation of the arbitration cases or those kind of things. So I think all this capacity building, we might still need to get the collaboration with foreign institutions as well. Even London Center, they also have some new rule, I think, on the relating to the IDA guideline on the ethics of the party representative, which they even incorporated into their rule. I think the rule 18.5 or something. So those are like, you know, a lot of ongoing process. It's never ending. So I think to make a research paper very solid and have a practical contribution, we might need to have a strong collaboration with foreign institutions as well. And when we got the product, the output, I wish that the other institution that might have some direct relevance to this type of research, even on the mediation. One of my students had a thesis paper on mediation even in 2019 already, the first one in Thailand. So I think that or the government sector that related to some certain type of the research topic, like mediation for investor state, or even mediation as a normal for international commercial arbitration or third-party funding interim measures. I wish that we could find a platform that we can link the product to the real user in the government sector or business sector or even for law reform commission as well. And again, I think if any of you as the practicing lawyer or professionals, if you have any idea about the contribution, or if you want to provide an internship program, feel free to contact us, at Chulalongkorn as well. Thank you.
Thank you.
So when we talk about this, I'm trying to list the venues in which education on ADR and arbitration can take place, at least in relating to the university students. Of course, there will be classrooms, right? No need to talk about that too much, but I just want to mention one thing. You can have many arbitration courses in the law school, maybe one focusing on arbitration law, for example. And another course on arbitration that I think may be useful and we may think we may need assistance from legal counsels outside the law school is the course on advocacy in arbitration, for example. I took that one at Yale and I think it was very enlightening and prepared me a lot for sitting as arbitrators. So that's for the classroom. The second venue whereby a lot of Thai students practice their arbitration skills is moot court, right? We have, of course, THAC. We have maybe the most important one now is the international one, with moot, right? And we may need your assistance kind of like in training our students, listening to our students whether they have good arguments or not. And if you have time, even like reviewing their memos, right? That's a lot of work, but that's something that we can have assistance from legal lawyers, practitioners, right? Another one, another venue is internship, right? THAC can lead in that venue in the sense that you open internship opportunity for students and you make sure that they have part, they play a part in dealing with real cases, not just doing research, right? Because doing research, they can do with me or Tidarat, but dealing with cases, that's something that arbitration institutions can provide for opportunities to students. And we have that with SIAC, right? But it's quite difficult for our students to go to Singapore, spend 2 or 3 months doing internship with SIAC, even though there's opportunity because a lot of costs involved, high costs, right? So that's something that THAC may want to think seriously whether they can allow the students to be a part of the cases, right? And of course, other than that, there will be kind of like these informal information sharing sessions by practitioners and lawyers. Now, of course, it will be difficult for students to come to this kind of event. So if we can read maybe online or maybe we have recordings, that will allow many students to at least learn when they are ready, right? Because sometimes it's difficult for them after like 8 to 5 classroom to come to sit in this event. It will be difficult. So these are some things that we can have. We will need collaboration from all of you, and so far I think we have had great cooperation with many practitioners in Thailand. So thank you so much.
How can others organizations contribute to the engagement of ADR?
I wanted to add to that. We with the YTHAC, we regularly post internship opportunities. So you should tell your students to follow our LinkedIn page. Because that's what we're trying to do, is have more conversations and link up all the initiatives that we're doing. Because I was just telling Professor Tidarat earlier that CIArb offers virtual internships for students for free during the pandemic, when students weren't available to get internships. And on the upside of your question of how to get students interested into ADR, there's also the question of students not being able to find jobs in ADR as well. So there's that balance, right?
So one of the most sought after events that we've been asked to do is a pure drinks only event, right? No need for hardcore knowledge transfusion. It's just for us to know each other better, right? For us to know who our families are, whether we have children, what our hobbies are, etc. And that forms a more closely knit community, a more, everyone knows each other, everyone is familiar with each other, and that helps when you're selecting arbitrators as well. So there is a BD element to it, but it's purely for people to get to know each other. And I think
we have to disclose that.
So that's something for us to think about.
Thank you, sir. Thank you, our distinguished panelists. Our participants, the discussion is almost over. Before we conclude the session, I would like to give you an opportunity to ask any questions to our panelists that you might have. Please.
My name is Chung. I'm an arbitrator, a constitutional arbitrator in Vietnam, and also the chair of the Society of Constitutional Law Vietnam. My question is, whether your academy is thinking about provide the ADR knowledge not only to law school, but also to technical students in Chulalongkorn, in IIT and Thammasat. The one who will be the civil engineer, electrical engineer, and also another one is want to provide training on ADR to the professional association, for example, the Association of Consulting Engineers of Thailand. I know that they invite some speaker from UK, from German or Indonesia to here to speak. But also construction arbitration and dispute law speaker from here. It will also promote THAC and arbitration.
Just want to add something. There's representative from construction lawyer society, and they engage a lot in like ADR arbitration related to construction. So I think they are doing very good job, and even if any of our assistants, feel free to contact Thammasat or other universities.
Thank you. It might not in the matter of arbitration, but I would like to close the session with my curiosity that one of the questions from our colleagues that what is my connection to arbitration or mediation. I don't have any direct connection to mediation, but recently I have brought 70 Buddhist Singaporean fellows from Singapore to practice the meditation in Thailand. So when you come to Thailand, it's globally well known for practice the meditation. I think that's the best way to resolve the problem. We need the peacefulness other than bring all quarrels and to in the court of justice and to the mediation. Thank you.
Thank you.
Very interesting. We talk about academic education and professional training program. I'm still a faculty at AIT, and I was the very first to create a course for students studying construction law. Yeah, and I still have my classes that I teach at AIT, and I've been teaching Vietnam too. Yeah, I'm going back and forth. So recently I was in Pakistan, where the government invited me to teach physics for the engineers specialized in dam management, energy management. And so just last month over there, we have 2 weeks of intensive training on, of course, physics books, from the red book to the yellow book to all the books of the construction industry. But I also organized a MOOC course that I created, with the party in Thailand, party in Pakistan, and some arbitration in Singapore. And it was a big success, right? And I even offered a THAC book to the academy there. So and I sent the report to THAC, my book here. It was very successful. So indeed, there is a big need for professional training programs. For how, especially now that there is a trend, there is a change in the concept of ADR. It's not anymore about who is right or wrong. It's about dispute avoidance, especially if you know the FIDIC book 2017 has introduced a new concept, which is not just the different tiers of dispute resolution. If negotiation doesn't work, you go to mediation. If mediation doesn't work, you go to arbitration, and so on and so forth. But now there is a new entity who has the power to bring parties together, what I call the art of amicability. This is something we are working on. So if you need any resource, I'll be very happy to contribute.
These are my question about the topic tonight. But I'm going to add some more information. I am a mediator of the Thai court, dozen years. So I agree with you that the mediator should be considered with emotion management. I agree with you 100%. And with Doctor, I agree with you that the mediator cannot use law. Next our competition and the judge. The mediator in Thailand is not non-paid job. It's voluntary job. So we cannot really judge from the mediator. The retired judge will come in to be with some mediators, and especially the insurance. We have a OIC. OIC is a Office of Insurance Commission. They settle the mediator process, and after mediator, if cannot pass this process, they will have an arbitration process in this Insurance Commission. So that's all what I want to share.
Thank you.
Okay, thank you so much. So I would like to conclude our session here today. So thank you, everyone. Thank you. Enjoy it.
for the invaluable insights and advice for the question. The moderator, it was a great pleasure to have you all participate in this session. Last but not least, I would like to thank you for your participation in this occasion. And once again, on behalf of Thailand Education Center, thank you everyone for participating. And please join the networking session afterwards. Thank you.